Trump rally, but it was delivered by a judge who is asking the United States Senate to confirm him to a lifetime appointment to a completely non-political position as the swing vote on the United States Supreme Court. It is the job of the Senate to decide whether or not to confirm Judge Kavanaugh. Senators must vote yes or vote no on elevating him to a lifetime appointment on the federal bench. It is not a criminal trial. Nobody is entitled to a lifetime appointment on the Supreme Court. If he is not confirmed, Brett Kavanaugh would still be serving as a federal judge on the second highest court in the United States. And the president, I am sure, will nominate another candidate for this job. For these reasons, I believe that Dr. Ford's credible allegations and Judge Kavanaugh's partisan venomous rant are sufficient reasons to vote no on his nomination. Now, my colleagues on the other side of the aisle saw the same hearing. They watched Dr. Ford sit through hours of testimony. They heard her when she clearly and unequivocally said she was 100% sure that Brett Kavanaugh sexually assaulted her. And they watched Judge Kavanaugh demonstrate to the world that he lacks the temperament and the truthfulness to sit on the nation's highest court. For those senators who don't care that Judge Kavanaugh thinks multiple sexual assault allegations he faces must be, quote, revenge on behalf of the Clintons, who simply aren't sure whether those credible allegations are a sufficient reason to vote no, and who would like to see more evidence, the sensible course of action has always been obvious: a serious, nonpartisan FBI investigation to uncover the truth as best we can, to make sure we are as informed as we can be before we have to vote. But that is not what has happened. First, instead of taking Dr. Ford seriously, Mitch McConnell scheduled a committee vote on Judge Kavanaugh's nomination the next day. He suspended the Senate vote only when it became clear that Republicans wouldn't have the votes they needed if they tried to ram the nomination through the Senate right at that moment. Then, the president offered the smallest fig leaf of an FBI investigation. Now, I have just come from the secure room where the summaries of FBI interviews and other FBI-generated documents were made available. Senators have been muzzled. So I will now say three things that committee staff has explained are permissible to say without violating committee rules. Statements that I have also independently verified as accurate. One, this was not a full and fair investigation. It was sharply limited in scope and did not explore the relevant confirming facts. Two, the available documents do not exonerate Mr. Kavanaugh. And three, the available documents contradict statements Mr. Kavanaugh made under oath. I would like to back up these 3 points with explicit statements from the FBI documents, explicit statements that should be available for the American people to see. But the Republicans have locked the documents behind closed doors with no plans to inform the American public of any new information about the Kavanaugh nomination. The Kavanaugh nomination was a sham, and that's the president's fault. Because the president is the one who limited the scope of this investigation, who refused to allow it to continue for more than a few days, and who refused to ensure that the FBI completed a thorough investigation, including interviews with all relevant witnesses. The statements the president made about the scope of the investigation were false. And if that wasn't bad enough, the president has viciously attacked Dr. Ford for bravely coming forward to tell her story. How could any senator accept this sham? It's clear, the fix is in. Republicans want to confirm Judge Kavanaugh to the Supreme Court, and they will ignore, suppress, or shout down any inconvenient facts that might give the American people pause about this nomination. Republicans are playing politics with the Supreme Court, and they are willing to step on anyone, including the victim of a vicious sexual assault, in order to advance their agenda. Judge Brett Kavanaugh's nomination to the highest court in our country is the result of a decades-long assault on our judiciary, launched by billionaires and giant corporations who want to control every branch of government. For years, those wealthy and well-connected people have invested massive sums of money into shaping our courts to fit their liking. Working in partnership with their Republican buddies in Congress, they have executed a two-part campaign to capture our courts. Part one, stop fair-minded mainstream judges from getting confirmed to serve in the federal courts. And part two, flood federal courts with narrow-minded pro-corporate individuals who will tilt the courts in favor of the rich and powerful and against women, workers, people of color, low-income Americans, LGBTQ individuals, people with disabilities, Native American students, and everyone who doesn't have money or power right here in Washington. With Trump in the White House and Congress controlled by Republicans, the wealthy and well-connected have a once-in-a-lifetime opportunity to control our courts for the next generation. During his presidential campaign, President Trump made clear that right-wing pro-corporate groups would not only have a voice in selecting Supreme Court justices, they would get to handpick their favorites. So those groups handed him a list of their top picks for the Supreme Court, and President Trump has picked judges exclusively from that list. His most recent selection is Judge Brett Kavanaugh. Now, there are a lot of reasons to oppose Judge Kavanaugh's nomination, and I want to discuss three of them: his record, the broken and biased confirmation process, and the allegations of sexual assault. Let's start with Judge Kavanaugh's record. Judge Kavanaugh has spent 12 years on the D.C. Circuit Court. His rulings demonstrate why radical right-wing groups and their friends in the Senate are so eager to give him a seat on the Supreme Court. Pick an issue, almost any issue, and there is ample reason to be alarmed. A woman's right to make her own health care decisions. When the Trump administration sought to block a young immigrant woman's right to access abortion care, Judge Kavanaugh sided with the government, claiming that allowing the woman who had done everything necessary to obtain access to an abortion should be further delayed in obtaining that care, a delay that would likely have prevented her from obtaining an abortion. And when religious organizations challenged the contraceptive care requirement of the Affordable Care Act, Judge Kavanaugh again opposed reproductive care, arguing that requiring religious nonprofits to submit a simple form allowing them to opt out of providing comprehensive contraceptive coverage, but ensuring that the employees had access to that care was unconstitutional. On consumer protection, Judge Kavanaugh ruled that the Consumer Financial Protection Bureau, the agency that stands up for Americans cheated by corporate criminals, is unconstitutional. On environmental safety, he has ruled to overturn the rules that help keep dangerous toxins out of the air we breathe and the water we drink. On voting rights, he upheld South Carolina's discriminatory voter ID laws. On gun safety, he dissented from an opinion upholding an assault weapons ban and a gun registration requirement. In speeches on gun safety, he admitted that most lower court judges disagree with his extreme position on the Second Amendment. On money and politics, he wrote an opinion that would permit foreign individuals to spend unlimited sums of money on issue ads in United States elections. Oh, and when it comes to presidential power and the rule of law, Judge Kavanaugh believes that sitting presidents shouldn't be subjected to personal, civil, or criminal investigations while they're in office. You know, that is very convenient for the current occupant of the Oval Office. And that's just the part of Judge Kavanaugh's record that we know about. And that raises the second reason that Judge Kavanaugh should not be confirmed to the Supreme Court: the secretive process that Republicans have used to advance his nomination. From the moment President Trump announced Judge Kavanaugh's nomination, Republicans have worked overtime to get him on the Supreme Court without giving senators or the American people a meaningful opportunity to examine his full record. Senate Republicans have played an elaborate game of hide the ball at every step in this process. Judge Kavanaugh spent many years in government, but the Republicans have refused even to request hundreds of thousands of documents from his time in service. They have designated other documents as, quote, committee confidential to hide them from the public. And to top it off, just days before Judge Kavanaugh was scheduled to come before the Senate Judiciary Committee, a Bush White House attorney announced that over 100,000 documents from Judge Kavanaugh's time in the White House counsel's office would be withheld on the basis of constitutional privilege. You know, a few years ago, President Obama nominated Elena Kagan to the Supreme Court. Like Judge Kavanaugh, she had participated in public office. She had served. But unlike the Kavanaugh confirmation process, the Kagan process included the release of nearly every document related to her time in service. In fact, no one has found an example of so much of a nominee's record in government being hidden from the Senate and hidden from the public as in Judge Kavanaugh's case. The rushed and secretive process that has characterized Judge Kavanaugh's nomination raises this question: what is he hiding? Why doesn't he insist that his record be made public? Why doesn't he want a full investigation of the sexual assault claims made against him? And why won't Republicans insist on transparency and a meaningful investigation? Evidently, neither Judge Kavanaugh nor the Senate Republicans care about the facts. Judge Kavanaugh has been accused of sexually assaulting multiple women. Dr. Christine Blasey Ford and Deborah Ramirez shared their stories of sexual assault at the hands of Judge Kavanaugh and risked their safety and the safety of their families to do so. Instead of making sure that these allegations are thoroughly investigated so that senators and the public can make judgments based on facts, Republicans launched a campaign to attack and discredit these courageous women. Donald Trump openly mocked Dr. Ford at a political rally, and the Republicans have made clear that their one and only goal is to get Judge Kavanaugh on the Supreme Court. In fact, just last week, Mitch McConnell told a group of conservatives, and I'm quoting here, "Don't get rattled by all this. We're going to plow right through it." Plow right through? Really? Americans are tired of the powerful plowing right through everyone else to get what they want. There's a reason why so many women and men have come out in droves to support Dr. Ford and Ms. Ramirez. It's because people are tired of being ignored and silenced. Judge Kavanaugh and his Republican sponsors don't want to talk about the facts in this case, but let's talk about a few other facts. Over 80% of women and 40% of men have experienced sexual harassment or assault. 7 out of 10 sexual assaults are committed by someone the victim knows. The vast majority of sexual assaults, about 2 out of 3, are never reported to the police. And why? Because survivors fear retaliation, or they believe that the police won't or can't do anything to help, or they think it's a personal matter, or they confide in someone other than the police, or they believe it's not serious enough to report, or they don't want to get the perpetrator in trouble. Last week, as Dr. Ford testified before Congress, the National Sexual Assault Hotline saw a 147% increase in calls from people seeking help. We have a problem of sexual harassment and sexual violence in America. The problem isn't that too many victims are coming forward with fabricated stories to destroy someone's life. It's that too many survivors are afraid to come forward at all. They believe they won't be heard or taken seriously, or they think more about the impact on the perpetrator than their own safety and well-being, or they think that people with power, the ones who can actually do something, will instead plow right through them. we never hear stories of the millions of sexual assault survivors. But some make the very difficult and personal decision to come forward and tell their stories. They, like all survivors, are courageous, and they deserve to be heard and treated with respect, not dismissed, not attacked, not threatened. The record, the process, the allegations. Whichever way you slice this, it should lead to only one result. Members of this chamber should vote no on Judge Kavanaugh. Our country deserves better. Thank you, Mr. President, and I yield the floor.
Mr. President.
The senator from New Mexico.
Mr. President, thank you for the recognition. Mr. President, first let me begin by saying this. I believe Dr. Christine Blasey Ford. Her raw courage coming forward will change the national culture and discussion. She has given voice to millions of women and men who are survivors of sexual assault, who were afraid to tell their stories, who felt powerless. Some of these women have contacted my office with their own stories. I have read them, and they are heart-wrenching. At its core, sexual assault is a crime of power. Dr. Ford has confronted some of the most powerful in our nation and told the truth. I thank her for her courage in coming forward and for empowering other survivors to do the same. Mr. President, at this point, with so much unknown, there are serious consequences to elevating Judge Kavanaugh to the Supreme Court. We, the Senate, need to continue our search for the truth about this nominee, his background, and his record. And hopefully, we can do that in a bipartisan way. Yet everything about the nomination process for this nominee has been deeply flawed. From the president outsourcing the nomination to the Federalist Society, to the majority leader violating his own new rule to delay consideration of a Supreme Court nominee until after an upcoming election, to a highly partisan lawyer screening Judge Kavanaugh's documents for public disclosure instead of the nonpartisan National Archive staff, to the Judiciary Chair's rush to hearing even though only 7% of Judge Kavanaugh's record is in the public domain. What are they trying to hide? I think we have a pretty good idea. And finally, and most disturbing, the president and the majority's inexcusable treatment of the brave women who have come forward with allegations of sexual assault and misconduct against the nominee. The Republican leaders claim to want to hear the allegations of sexual assault has been nothing but a cynical show of public consumption, for public consumption. The Me Too movement forced them to open the floor to Dr. Ford, but her testimony was never really going to matter to President Trump and the Republican leadership. The majority leader made that clear when he bragged to an audience of the religious right before her hearing that, and I quote here, "In the very near future, Judge Kavanaugh will be on the United States Supreme Court," end quote. Republican leaders question why the allegations hadn't come forward sooner. But the reasons why survivors of sexual assault often don't come forward is well documented and well understood. And they did everything they could to undermine getting to the truth of Dr. Ford's allegations, from refusing to honor her request for an FBI investigation prior to her hearing, to severely limiting the Democrats' time for questions of Judge Kavanaugh before the Senate Judiciary Committee, to refusing to call other key witnesses like Mark Judge, Deborah Ramirez, and others, and to put them under oath. And it is absolutely stunning that all 11 Republicans on the committee abdicated their responsibilities and ducked public scrutiny by bringing in a female prosecutor to do their job and question Dr. Ford. It's just plain political cowardice. And women in New Mexico and around the country are watching. Mr. President, again, after hearing her testimony and reviewing the record, I believe Dr. Ford. It's worth noting that no Republican senator has said she is not credible. Not a single one has said she's not credible. The majority whip stated, and I quote here, "I find no reason to find her not credible," end quote. The president found her testimony, and I quote here, "very compelling, that she was a very credible witness," end quote. Although true to form, the president changed political course and insulted and mocked her in front of a laughing crowd and television cameras. Yet another shameful new low for the president's treatment of women. Dr. Ford's testimony was all the more compelling because she was able to expertly explain how the memory of the assault is seared in her hippocampus by neurotransmitters released in response to the attack. Her memory of her assailant is fully intact. It insults Dr. Ford and survivors generally to say, like Republicans have, that you believe something happened to her, but that it wasn't Brett Kavanaugh. Dr. Ford is not mixed up. And contrary to what the Republicans would tell you, there is strong corroborating evidence behind her allegations. Years before this nomination, she had told her husband, a therapist, and friends of the attack. And her polygraph examination supports her truthfulness. Her story even matches an entry in Judge Kavanaugh's calendar in a number of ways, identifying the attendees she would have no reason to know. There is a narrow window where it's possible that both Dr. Ford and Judge Kavanaugh are telling the truth. And that is if Judge Kavanaugh does not remember it as a result of his consumption of alcohol that evening. But Judge Kavanaugh's performance during the supplemental hearing, while loud and angry, was not convincing. You can't find Dr. Ford's testimony credible and at the same time push to put Judge Kavanaugh on the court. The burden of proof for a lifetime appointment to our highest court is not beyond reasonable doubt. The Senate and the American people must have a high degree of certainty that there was no sexual assault and that the nominee didn't lie about it under oath. We have no certainty on either count. The supplemental hearing brought Judge Kavanaugh's overall credibility even further into question. While he denied reports of heavy alcohol use during high school and college, there are abundant reports in the press and statements from many eyewitnesses to the contrary. Numerous acquaintances, even friends, have come forward with information that he often drank to excess during these years. His own yearbook quotes, allude to, brag about heavy drinking and exploits with girls. With all these accounts of heavy drinking from an array of different credible sources who have nothing to gain by coming forward, it is hard to believe there's no truth to them. Evidence of excessive drinking and inappropriate behavior as a teenager and young adult is not disqualifying in and of itself, but misleading Congress and the American people about it is. Most troubling is that there was already evidence before us that Judge Kavanaugh has not been fully truthful. We know that when Judge Kavanaugh worked as White House lawyer on George W. Bush, under George W. Bush, Senate Republican judiciary staff stole confidential information from Democratic senators and staff, and they gave some of that stolen information to him. Judge Kavanaugh denied under oath that he knew the information was stolen, but if you read the email correspondence, it is nearly impossible to believe that a sophisticated political operative like Brett Kavanaugh would not have understood that the information had been obtained surreptitiously. There are also valid concerns that Judge Kavanaugh misrepresenting during his 2004 confirmation hearing about his involvement with the George W. Bush torture policy and with certain judicial nominations he handled as White House counsel. His sworn testimony in 2004 and the two recent hearings leave me highly skeptical that Judge Kavanaugh has told the whole truth and nothing but the truth before Congress. I cannot support a nominee to the Supreme Court without a high degree of certainty that he or she has been 100% honest under oath. The integrity and reputation of the Supreme Court demand nothing less. The rushed judiciary hearing with Dr. Ford and Judge Kavanaugh was designed to appease and not to make sure the American people had all the facts. Senator Flake was right to stop the process and call for an FBI investigation. He is right that this nomination is tearing the country apart. The American people needed to know the truth. All relevant evidence should have been gathered and put before us. Senator Flake is a friend, and I commend him for standing up for what he thought was right. But an artificially limited FBI investigation will do nothing to bring this country back together. Justice could have only been served with a full investigation, with the FBI allowed to do their job as they know how to do it. But with the results of the FBI investigation in, it's clear that the President, with the Senate leadership in full support, imposed arbitrary limits on the scope and length of the investigation. Dr. Ford has not been spoken to. Her corroborating witnesses were not contacted. Her corroborating documents not reviewed. There was no meaningful inquiry whether Judge Kavanaugh misrepresented his past alcohol use, which also corroborates Dr. Ford's story. Up to 40 witnesses tried to come forward, but FBI agents did not contact or interview them. While we can all read their statements in the newspapers, their information won't form part of the FBI investigation record. There has been no bipartisan briefing where senators can ask FBI leaders about the adequacy of the investigation. The FBI investigation was not allowed to be a real investigation. And given what is in the public record, but kept away from the FBI, it by no means exonerates Judge Kavanaugh. Without a real investigation, the cloud of credible allegations remains. The President and Republican leaders were simply not on a search for the truth, only a mad dash to get Judge Kavanaugh confirmed at any cost to the country. Folks, it's 2018. We are 27 years beyond Clarence Thomas's hearings. Yet credible claims of sexual assault against a nominee to the Supreme Court are not taken seriously by the President of the United States or the Republicans in the United States Senate. The roughshod process orchestrated by the Senate majority and the President delegitimizes the claims of a woman subject to sexual harassment and sexual assault, and it only serves to drive survivors underground. And the kangaroo court-type process orchestrated by the Senate majority and the President delegitimizes the Supreme Court and will for decades to come. During the supplemental hearing, Judge Kavanaugh showed himself as partisan, belligerent, even paranoid, and lacking in judicial temperament. He rudely shot back at senators asking him about their drinking habits. He accused members of the minority of misdeeds for which he had no evidence. He blamed revenge by the Clintons for the predicament he is in. He lacked self-control, dignity, and the temperament of a Supreme Court justice. His partisanship and lack of political independence were on full display. I have never seen a nominee to a federal court, let alone the Supreme Court, behave in such an injudicious manner before the Senate. Under pressure, Judge Kavanaugh did not show himself worthy to appointment to the highest court. This is not a partisan conspiracy, as Judge Kavanaugh claimed. We saw no such allegations for Judge Gorsuch's nomination, a judicial candidate who shares a similar judicial philosophy to Judge Kavanaugh and coincidentally went to the same high school. There were no unsavory allegations against Judge Scalia or Judge Alito, two judges that most Democrats vociferously opposed based on their right-wing, pro-dark money ideology. Elevation to the Supreme Court for a lifetime appointment is not a right, it's a privilege. And while the Republicans take great umbrage that Judge Kavanaugh's reputation is at stake, the fact is we have before us credible allegations of sexual assault and sexual misconduct, and justice demands that he be called to answer those allegations. He should not get a pass. Mr. President, I've reviewed Judge Kavanaugh's decisions, writings, and speeches, all his testimony before the Senate Judiciary Committee, the meager set of documents made available when he served as a White House lawyer and as part of the independent counsel Kenneth Starr's investigation. On the merits, this nominee simply does not represent mainstream judicial thought. He is on the extreme edge. But the American people want a justice whose judicial philosophy falls within established parameters. A justice who is not on the far end of the ideological spectrum, who will not put his or her personal beliefs before the text of the statute or constitutional provision at issue. Even before the allegations of sexual assault and misconduct, the American people opposed this nomination in unprecedented numbers. I, like the American people, have no confidence this nominee will uphold our rights of privacy, a woman's right to choose, and each individual's right to marry whomever they want. I have no confidence that this nominee will uphold Americans' rights to health care, consumers' rights to a fair deal, or laws that protect our environment and combat climate change. I have no confidence that this nominee will protect minority rights and the rights of Native peoples in particular, or will uphold voting rights, strike down gerrymandered voting districts that undermine the principle of one person, one vote, or rein in dark money that erodes our democracy. And as the nation faces the distinct possibility that special counsel Robert Mueller's investigation will find evidence that the president or his campaign conspired with Russia to undermine the 2016 presidential election, evidence that the president obstructed the special counsel's investigation, or evidence of other crimes, I have absolutely no confidence that this nominee will hold the president to account if called to do so. Judge Kavanaugh is on record that as a matter of policy, he believes the sitting president should be immune from criminal investigation while in office, no matter the crime. And he has refused to tell the Senate and the American people whether he believes that. As a matter of constitutional law, a sitting president may be investigated and indicted. I, for one, believe that under the Constitution, if a president commits a crime, the rule of law still stands, that the Constitution gives no immunity to a president who is a criminal. This nomination will shape the course of the Supreme Court and American law and lives for decades. We must have a nominee who has been fully vetted, who does not stand credibly accused of sexual assault, whose honesty before the Senate and the American people cannot be questioned, whose judicial record fits within mainstream jurisprudence, and who believes that no one, not even the president, is above the law. Judge Kavanaugh is not that nominee. Mr. President, I yield the floor.
Mr. President.
Senator from Arizona.
Thank you, Mr. President. This is the first time that I have had the opportunity to address my colleagues on the Senate floor since I was appointed to fill the seat of our late friend and colleague, John McCain. And I appreciate the opportunity to speak on a matter of great importance both to this body and to the people of the United States of America, namely the confirmation of Judge Brett Kavanaugh as Associate Justice to the United States Supreme Court. I'd like to address this in 5 general areas, beginning with a couple of preliminary areas of discussion. The first concerns my work right after I came to the Senate in 1995 to try to adopt a constitutional amendment for the victims of crimes, the Crime Victims' Rights Amendment, we called it. I have become acutely aware of the problems that crime victims face, especially those who have suffered some kind of sexual abuse. And through personal interviews and discussions with victims' rights groups, with prosecutors and others, with research and a great deal of reading, and hearing from victims groups, law enforcement and others, I became convinced that the only way that we could guarantee the rights of these victims and to bring justice to them would be through the adoption of a constitutional amendment doing so. I worked with Senator Dianne Feinstein. The two of us joined together in this effort, and we spent countless hours and many, many months trying to persuade our colleagues that this was the way to proceed. Eventually, we were able to get legislation through the Senate which established a federal law rather than a constitutional amendment. And this federal law, which is now embodied in 18 U.S.C. 3771, has provided some support to victims of federal crime and, as importantly, a template for states to develop their own statutes and constitutional amendments to provide rights to victims. As a result of all of this, Mr. President, I am well aware of the issues like delay in or non-reporting of assaults by crime victims, and I very much appreciate the need to be lenient in evaluating the testimony of such victims. Rights like the need to attend proceedings and to address the court at the time of sentencing and to be notified of these rights were included in the statute that we got adopted. And those rights are now part of a majority of the states of the Union, either in statute or constitution. the recognition of the rightful role of victims in our criminal justice system can not only help provide courage and closure to victims of sexual assault, it thereby also helps prosecutors gain critical testimony for their cases so that more of the perpetrators can be brought to justice. Now, there are some insensitive people who are not aware of the difficulties faced by victims of sexual abuse, and you've heard some of them speak publicly. What is not true is that all men are ignorant of the problem. Senator Feinstein and I met many men in the victims' rights movement who are extraordinarily helpful and understanding. I don't ask anyone to establish their bona fides to speak to any of these issues, and I would hope that none would question mine. To the second point, some have asked me about my time in helping Judge Kavanaugh as a so-called Sherpa. This was part of the early process of his confirmation process where he was interviewed by the majority of the senators and tried to answer their questions and also to respond to requests for information and the like. Just before his nomination was announced by the president, Don McGahn, the White House counsel, called me in Arizona and asked if I would serve as the Sherpa for the nominee, the person to get him around the Senate, introduce him to the senators, follow up on any questions, and so on. And I agreed to do that, and I also participated in some of the hearing preparation. This all occurred over about a 5-week period of time. During this time, I was employed part-time at a Washington, D.C. law firm. But I want to be very clear that my assistance to Judge Kavanaugh was on my own time, free of charge, and in no way connected to the firm or any client of the firm. It was not a pro bono matter because I actually didn't represent Judge Kavanaugh. It was simply to help him prepare for his hearing and to get him around the Senate to meet the senators and to talk to them. When I was appointed, after about 5 weeks of this, roughly, I was appointed by Arizona's governor to Senator McCain's seat here in the Senate. And I immediately resigned from the firm and all other remunerative positions and ceased working with Judge Kavanaugh. I should also mention that during this time, I performed no lobbying work for my law firm or for any clients of the firm, and I so notified the Secretary of the Senate and the Clerk of the House. And finally, Mr. President, at no time during my work with Judge Kavanaugh did any allegation of sexual impropriety arise. The Ford allegation came after, and nothing like that was discussed in my presence during my work with him. As I said, some have asked me questions about this. I hope that satisfies their inquiries. I also want to just conclude this part of the presentation by saying that having sat through over 50 interviews, heard the questions asked of him and his responses, many of them repetitious, and helped him to prepare for his hearing, I really believe I've got a very good idea of how he would conduct himself as an Associate Justice on the U.S. Supreme Court. And that, after all, Mr. President, is the most important question before us. So the third area of inquiry gets to Judge Kavanaugh as Justice Kavanaugh. The first thing to do is to examine his qualifications and experience. This is ordinarily where we begin in our inquiry to provide advice and consent to the President after a nominee. A graduate of the Yale Law School, clerkships on both the Ninth Circuit Court of Appeals and the United States Supreme Court under Justice Kennedy. He's been described as wicked smart and extraordinarily hardworking. He went over this on numerous occasions, discussing his early service on the Court of Appeals, where he wanted to emulate Judge Merrick Garland, who we've heard something about. Merrick Garland is a prodigious worker by reputation, and Judge Kavanaugh saw that and tried his best to follow in Judge Garland's footsteps in that regard. He's had a huge output in cases, I believe 312 written opinions over his 12 years on the bench, and in addition to that, outside the court, law review articles, speeches, and many presentations to groups. He also lectures at the Harvard Law School. And regarding his previous experience, it also includes, as we know, a previous experience in the executive branch, both as a lawyer and as an assistant to the president. In all of this, by the way, he was required to undergo 6 separate FBI checks. His qualifications have been reviewed by the American Bar Association, which is just one entity that looks at judicial nominees and is generally deemed to be an organization that studies records, it goes into depth in interviewing people, and they concluded that he had the top rating, well qualified to serve on the Supreme Court. He is, as some have described, a judge's judge, a real standout on the bench. People would have been surprised if he were not someday nominated to serve on the U.S. Supreme Court. He's also been recommended by law professors and students and former clerks and hundreds of people who have written letters in his behalf. And I note that many of these are liberals, are Democrats. They're not necessarily conservatives or Republicans. He is well regarded by virtually everyone who has had connection with him, either in his profession or as a member of the bench. The next question that we go to in evaluating a nominee to a court is their judicial philosophy. How do they approach the job of judging? How will they decide cases? Now, I first want to say what Judge Kavanaugh is not, and he made this crystal clear in the many meetings in which I sat with him discussing with senators. He's not a results-oriented judge. He doesn't decide when the parties come before the court who he wants to win and then figure out a way to help that party win the case. That is not the right way to evaluate a case before the court, and he is not that kind of judge. He is a judge that wants to apply the law in the right way and to reach the decision that the law requires based upon precedent, based upon the way that the Constitution or appropriate statutes are to be interpreted in order to reach the right result in the case. One of my colleagues on the Judiciary Committee, I think, got us off on the wrong foot, or tried to get us off on the wrong foot in this regard. He came to one of the hearings with a presentation on how many times Judge Kavanaugh allegedly ruled for corporations over individuals, and concluded that this was an important factor in determining whether Judge Kavanaugh should sit on the Supreme Court. And I think this does illustrate the mindset of many. Who did you rule for, rather than how did you rule in the case? This is totally wrong, and it's irrelevant to the way judges should decide cases. Theoretically, if 10 plaintiffs bring 10 spurious lawsuits against 10 different corporations, and the courts rule for the corporations in those cases, it proves exactly nothing. And that's why we shouldn't focus on who wins the cases, but rather on whether they were decided based upon proper legal principles, on precedent, and on the way that courts are supposed to approach cases on the facts and the law. Judge Kavanaugh, in the meetings that I sat in on, went to great pains to describe how he approaches a case. And he begins by looking at the text of the Constitution or any relevant statutes. He begins applying the law as judges are supposed to do in interpreting those constitutional provisions and statutes. And in the process of doing this, he uses the same principles that other judges do, and I'll mention in just a moment what some of those principles are. But I mentioned the fact that some of my colleagues have focused on who he has ruled for in cases. Now, bear in mind that as a member of the U.S. Court of Appeals, he sits with 2 other judges. So the 3 judges decide the cases, not just one, although a case can be decided by a 2-to-1 vote. But some of my colleagues have said, well, they're concerned that because he served in an administration for a president, and because of something he once wrote for a law review article, that they fear that he would want to rule for the president and against other parties if a lawsuit involved the question of executive power. How much authority does the President of the United States enjoy? I think that's wrong based upon his explanation of all of his decisions and what he has written on the subject. I think it's very clear that he has no predilections in this regard, and that he believes strongly in the separation of powers as set forth in the U.S. Constitution, that he holds no special place for the president above the other two branches of government. One of the cases that he cites to demonstrate this fact is a case that didn't please me, and the outcome certainly didn't please his old boss, President Bush, because he ruled against President Bush. Instead, he ruled for Osama bin Laden's assistant and driver. And the reason he did that is because he said that that individual, as bad as he may be, as evil as he may be, was not accorded proper constitutional rights as guaranteed under our Constitution. And he had to reach the result that he did because of that. As I said, I didn't like the outcome, and I'm sure his previous boss, President Bush, didn't either, but it illustrates the fact that he's not going to blindly rule for the president, even in a case where the equities would seem to favor what the president was trying to do in this case, and that is to ensure that Osama bin Laden's colleagues were held to account for their misdeeds. So bottom line here is it's not who wins and loses that matters, it's whether the law is applied fairly and correctly. Now, how do we know whether it's correctly applied? Obviously, judges will differ sometimes, and each case is going to be decided on its own merits. The question of how one judges is really the key to this. I said I would get to it. And here's just a little bit of a discussion of how cases should be decided, how judges should approach these decisions, and how I believe Judge Kavanaugh would. It's based on legal rules and principles that have been long established and written up and followed by courts throughout the ages. The law is literally full of these rules, basically the how-to for judges to decide difficult cases. And most judges know and apply these rules fairly and systematically. They don't try to make up new rules or deliberately fudge the facts or twist the rules in order to reach a desired result. I kind of liken it to the instructions that come with those dreaded packages that say some assembly required. That's always a sign that I need to get my wife involved rather than for me to do it myself, because I don't follow directions very well. But a failure to follow the steps in that case can lead to some pretty bad results, as a couple of lawn chairs I put together will attest to. The question here is, a judge should have a clear view of how he approaches each case, the steps that he follows to decide them. But sometimes cases provide ambiguities and difficult decisions that make it especially difficult to apply the usual rules. And in these cases, the question is whether a judge will be tempted to guess what the right procedure is, or to try to reach an outcome that he's predetermined he wants to reach, as opposed to applying other common sense principles. And it is true that sometimes laws are ambiguous and they require some interpretation. I've seen Judge Kavanaugh address this precise question and to go over decision after decision that he has made, showing how he approaches cases like this. And I can tell you, first of all, he tries to get his colleagues to agree, if a reading of a statute is not really all that ambiguous, to say, look, if you find my reading of the statute persuasive, then that should be it. That should end the inquiry. We don't have to find ambiguity in every single thing. Because when ambiguity is found, obviously judges are not as tethered to the law as they would otherwise be. He is very aware of this, and he has tried very hard, I think, to reach the right conclusion based upon a proper application of the law. And I'm not going to go into all of those judicial rules. We've heard of precedent and statutory interpretation and the like, but I will say that having heard him describe his approach to numerous cases, I am convinced that he will, as a justice on the Supreme Court, apply the law in the same way that he has on his 12 years as a member of the Court of Appeals. He describes his approach to judging in a way that some have called strict construction or textualism, which I think is really not much more than giving a preference to the written text of either the Constitution in cases where constitutional interpretation is the question, or statutes in cases where statutes have to be interpreted. This approach to judging is more the methodology that's used more and more today by judges, and it tries to avoid substituting the judge's notions of how things should come out and substituting the judge's discretion as opposed to carefully reading the text of the Constitution or the statute as either the Founding Fathers or the Congress, in the case of statutes, has written it. As I said, during his many interviews, in hearing him explain his approach, I believe he's given us a very good idea to how he would approach cases in the future. And as I said, while there are one or two areas that some of my colleagues have raised questions about, I have no doubt at all that he is an extraordinarily knowledgeable and very wise judge who will do what he is supposed to do on the Supreme Court, to apply the law fairly and correctly. And I also believe something else, that he's going to work very hard to find consensus on the court. We all hear about 5-4 decisions, and they don't make us feel good because it illustrates how judges can differ, and it sometimes demonstrates an ideological division on the court, which we would hope to avoid. He would like to work with his colleagues to try to come to more consensus decisions than to have these kinds of split decisions. He really loves the law, and you know that when you talk to him, and he's really committed to making it work. Another critical factor for a judge, and we frequently refer to it, it's been referred to on the floor here, is what we call judicial temperament. This is especially important in district court judges, where they appear before juries and where trials are actually held. You want the jurors in the case to understand the case well, to feel good about being there as jurors, judging their fellow citizens. And judicial temperament is very important for the judge in those cases. But even on a court of appeals, one must have judicial temperament that demonstrates to the parties, to the litigants, that the judge is fair, that demonstrates to the lawyers involved that he can be respectful of them and fair to all of them, and that he can be congenial with his fellow judges on the court, with whom he has to work every day and decide these cases. Up until the second hearing for Judge Kavanaugh, following Professor Ford's testimony, I don't believe anybody really questioned Judge Kavanaugh's judicial temperament. His 12 years on the Court of Appeals for the District of Columbia revealed a very careful and courteous and engaged judge, fair to the parties, reasonable to the lawyers, and collegial to his colleagues. It was only when responding to the attacks on his character that he even showed much emotion. And I believe that most honest observers would allow him some slack for that in view of the nature of the allegations against him. Much like the need to show some lenience in evaluating the testimony of a victim of sexual assault, I think we can appreciate the role of emotion in his testimony. He apologized to the one senator to whom he was rude, and in my view, the best evidence of his temperament as a judge is his temperament as a judge for the last 12 years. So as to judicial temperament, knowledge of the law, and approach to deciding cases, I believe few would doubt his qualifications to sit on the U.S. Supreme Court. That brings us to the fourth part of my presentation here, the allegations of sexual misconduct against him. Do they amount to something that should disqualify him for serving on the Supreme Court? I don't think I need to detail here every allegation and every witness statement that has been involved in the investigation of these allegations. In the recent hearing at which both Professor Ford and Judge Kavanaugh testified, I believe most observers saw both as presenting credible testimony, and I agree with that. That their recollections differed does not necessarily mean that either of them knowingly lied. We should neither automatically believe one over the other. She because her testimony was that she had been sexually abused, nor he because he's a sitting federal judge. As I said, each deserves some deference for the reasons that I stated. But if both are believable, we must still find a way to analyze the evidence to help us reach a conclusion on the issue before us, should Judge Kavanaugh be confirmed. Well, the best way to verify the allegations is through corroboration, evidence that backs up the accusations that have been made. While both Professor Ford and Deborah Ramirez have named individuals who they believe were present during the incidents of which they complained, none of those individuals would corroborate the accusations. Some denied them, Others had no recollection of such incidents. Some said, even so, they believe Judge Kavanaugh. At least one says the same as to Professor Ford. There does not appear to be any corroborative evidence. Professor Ford's telling of her story later to others is not corroboration, but it does go to her credibility. That she did not report her incident earlier is not dispositive. Victims in similar situations frequently do not report for a number of reasons. The fact that her very good friend, allegedly at the party in question, and the only other girl present, according to Professor Ford, did not become aware of the accusations that night does raise some questions. And that particular witness, despite her obvious friendship with Professor Ford, has continued to insist that she has no recollection of the party in question or of Brett Kavanaugh. I have either read all of the FBI notes or had them read to me and have been briefed by the committee staff on all of the FBI and committee contacts. And this includes the second round of FBI interviews. Contrary to what some have said, this process was not constrained. The FBI was not told not to interview certain people. They were, in fact, told to follow the leads. And I believe that they interviewed not just 4 witnesses, but a total of 10 witnesses in this latest round of their interviews. After reading what I have read and being briefed on the remainder by committee staff, I find nothing to verify the accusations against Judge Kavanaugh. He has unequivocally denied them, and having gotten to know him as I have, I conclude he is not the proper subject of the accusations. Some have suggested that he must prove that he did not engage in the conduct alleged. It would be totally unfair to place upon him the burden of proving a negative. This is ordinarily impossible. When you neither know the time nor place of an event alleged, you can't disprove that you were there then, there, wherever it was, or then, whenever that was. In this particular case, for example, unless he could somehow show that he was in Europe the entire 3 months of the summer allegedly involved here, or some similar thing to that, there's no way that he could prove a negative, namely that he wasn't there. It's true that the presumption of innocence applies in our courts, but the same notion of fair play applies in other aspects of our civic and social life. If a mere allegation of wrongdoing is enough to deny an applicant a job or otherwise discredit an individual for the rest of that person's life, our society would be torn apart. This is why we have constitutional rights, which embody our notions of fair play in life generally. Now, while this is not really a job interview, as it's been described, even if it were, and we were the prospective employers, we would want to evaluate the qualifications, in this case of Judge Kavanaugh, including accusations against him. And those accusations would not just be taken at face value, particularly as serious as they are in the fact that he has unequivocally denied them. So I conclude that under all of the circumstances, including the nature of the evidence brought forward and how that evidence would be proven to us, I conclude that including how he has lived his adult life, and after 7 FBI investigations now, it is more probable than not that the accusations against him are not true and therefore disqualifying for his nomination. And that brings me to the 5th and final point of my discussion, Mr. President. Lifelong considerations of suitability to serve. I noted the qualifications for judges, their judicial temperament, the way they approach judging cases, their record of writing opinions, what they've said and how they've said it. That's the first thing we look at. But we also look at the whole person, and that's an appropriate thing to do. So let's look at Judge Kavanaugh's whole person. First of all, I would like to denote some things that I think are not relevant to his competence to serve on the Supreme Court, but which we've heard a lot about. Not relevant are Judge Bork, Justice Thomas, or Judge Garland, or arguments about who started the unseemly process we're in now. By the way, let me just as an aside here note that in one of the interviews with a senator, the interview started as follows: Judge Kavanaugh, glad you came in today, but I can tell you that this is going to be very, very hard because of what happened to Judge Garland. Well, you can have your views as to whether Judge Garland was treated fairly or not, but that should have no bearing on the qualifications of Judge Kavanaugh to be confirmed to the United States Supreme Court. Other not relevant things are comments from the President of the United States, including unfair comments about Professor Ford. Also not relevant is the outcome of this debate on elections or on President Trump's future. Nor is this about punishing Judge Kavanaugh because some crime victims have not previously received justice. The most recent claim here now is about process. I think his qualifications having been well established, now the claim is the process is lacking, is not fair. Obviously, what this is not about is whether the FBI was allowed to do its work, as I believe it was. The vote we'll be casting tomorrow should not be a surrogate for some other agenda. It should be simply our judgment of Judge Kavanaugh's fitness to serve on the United States Supreme Court, our advice on and potential consent to his nomination by the President. As I said, having been with him in interviews with the majority of my colleagues and otherwise gotten to know him, and having witnessed and learned of the esteem in which he is held by colleagues, by former law clerks and students, professional friends, and being aware of his contributions to his community, his country, his church, and his family, I conclude that he is eminently qualified to serve on the Supreme Court and will serve the nation well in the position of Associate Justice. As I said, Mr. President, the best evidence of how he would perform as a justice is how he has performed over the dozen years that he has been a judge on the U.S. Court of Appeals for the District of Columbia. I urge my colleagues to focus on the question at hand, and I urge them to support Judge Brett Kavanaugh's nomination to the United States Supreme Court.
Mr. President.
The Senator for Hawaii.
Mr. President, tomorrow we will cast a very important vote on whether to end debate on the nomination of Brett Kavanaugh to be an Associate Justice of the Supreme Court of the United States. Should he be confirmed to this position of awesome responsibility, Judge Kavanaugh would be just one of 9 people with the power to change the American government and the American way of life for at least a generation. He would be hearing and deciding cases that touch all facets of our lives, including the health care we receive when the Texas case involving the Affordable Care Act's individual mandate makes its way to the Supreme Court. And this particular case is very important because if Texas wins, that means that the ACA's protections for those with pre-existing conditions, 1 out of 4 people in this country, would be done away with. The Supreme Court will also get probably a lot of immigration cases, in many cases about DACA, sanctuary sites, temporary protected status, and family separation that are pending in the lower courts. Abortion, as courts weigh the burden imposed on a woman's right to choose by laws limiting abortion in states like Texas, Iowa, and Louisiana. So it doesn't really matter. Of course, it matters whether Roe v. Wade is overturned, but even if Roe v. Wade is not overturned, with Judge Kavanaugh's record, all of these limiting laws by states that I just talked about will probably be supported by him. And at some point, the right to an abortion that we have under Roe v. Wade will be pretty much a nullity. The Supreme Court will also be faced with cases that will address the right of workers to bargain collectively with their employers as litigation comes up to the High Court in the wake of the Janus decision, and many other important topics, including voting rights, gerrymandering, the census, race-conscious college admissions, and environmental laws. The Supreme Court's decisions touch every aspect of American life. With so much at stake, the Senate has an obligation to closely scrutinize every nominee to the Supreme Court. We need to know that they have the qualifications for the job. Do they have the proper education? Do they have the necessary breadth of experience? Will they treat everyone in the court, including court employees, law clerks, and lawyers, with an even temperament? Can they keep their cool under pressure and make reasoned decisions when the stakes are high? Can they listen to the facts and apply the law without fear or favor? Or will they let the experiences they bring with them override objective judgment? Will they insert their personal preferences where they don't belong? We need to know if they can rule fairly. Will they give every litigant who comes before the court a fair hearing? Will they acknowledge and put aside their biases, inherent and otherwise? These last two considerations are especially important because the Trump administration outsourced the vetting of Supreme Court nominees to the Federalist Society and the Heritage Foundation. These ultra-right-wing groups have spent decades supporting people like Brett Kavanaugh and their ideological, outcome-driven jurisprudence. After months of scrutinizing Judge Kavanaugh's record and evaluating his performance before the Judiciary Committee in 2 hearings, it's clear the answer to most of these questions is no. His judicial record is deeply ideological and outcome-driven. He remains a fierce political partisan operative, and he holds troubling legal views on Native Hawaiians, Native Americans, and Alaska Natives. These patterns were clear based on the weeks I spent reviewing Judge Kavanaugh's writings, his judicial decisions, and the small fraction of his record made available from his time as a key White House aide to President George W. Bush. I became even more certain of my decision to oppose his nomination after his first hearing in the Judiciary Committee and after reading the mostly dismissive non-answers he gave to our follow-up written questions. There are plenty of substantive reasons to oppose Brett Kavanaugh's nomination, and I will continue speaking out about many of these reasons in the coming days. But over the past 2.5 weeks, we've learned new information that underscored my concern that Brett Kavanaugh lacks the character, candor, credibility, and temperament to serve on the United States Supreme Court. Last week, the Senate Judiciary Committee heard testimony from Dr. Christine Blasey Ford and Brett Kavanaugh about Dr. Ford's account of an attack on her by the nominee and a friend when they were all teenagers. Dr. Ford conducted herself with grace and courage, recounting the terrifying experience that has had a lasting effect on her life. In his testimony, Judge Kavanaugh dropped the polite veneer he presented at his first hearing, during which he complimented all of the senators he'd met with and told the committee that, quote, the Supreme Court must never be viewed as a partisan institution, end quote. That was then. But last Thursday, he launched into a partisan political screed that contradicted everything he has ever professed to believe about the way judges should behave. He said, quote, this whole 2-week effort has been a calculated and orchestrated political hit fueled with apparent pent-up anger about President Trump and the 2016 election, fear that has been unfairly stoked about my judicial record, revenge on behalf of the Clintons, and millions of dollars and money from outside left-wing opposition groups, end quote. I have to say, sitting there listening to him be so totally partisan was bizarre. What he said was bizarre. He was angry, he was belligerent, he was partisan, he went on the attack, he argued with senators, he forgot who was there to ask the questions and who was there to answer them. These are not qualities to look for in a Supreme Court justice. More than 1,700 law professors across the country agree, including Dean Avi Soifer and 6 other professors from the University of Hawaii and 21 professors from Georgetown University Law Center, both my alma maters. I want to quote from what the law professor said. We have different views about the other qualifications of Judge Kavanaugh, but we are united as professors of law and scholars of judicial institutions in believing that he did not display the impartiality and judicial temperament requisite to sit on the highest court of the land, end quote. Mr. President, I ask unanimous consent that a copy of this letter from the law professors be inserted into the record.
Without objection.
Judge Kavanaugh also tried to convince us that while he liked beer, he was basically a choir boy, interested in nothing more than sports, school, and service projects. This carefully painted image has been directly contradicted by Judge Kavanaugh's own words in his yearbook and by many of his high school and college classmates over the past weeks. These inconsistencies and contradictions were part of the reason why I joined many of my colleagues in calling for a full FBI investigation of allegations against Judge Kavanaugh. I wanted the FBI to examine inconsistencies and contradictions between his testimony and that of others who knew him in high school, college, and beyond. Last Friday, Senators Flake and Coons brokered an agreement to hold off on a floor vote for at least a week while a supplemental background investigation could be completed to look into these allegations. But I was disappointed that as the days went by, it became more and more clear that the White House rigged the investigation. The president claimed to want the FBI to do a comprehensive investigation, but that did not happen. Our ranking member, Senator Feinstein, wrote to White House counsel Don McGahn and FBI Director Christopher Wray the day after the investigation began to require a copy of the written directive sent by the White House to the FBI. She got no response. The following day, many other members of the committee also wrote to Mr. McGahn and Director Wray about the supplemental investigation. In addition to repeating the ranking member's request for an explanation of the scope of the investigation, we also asked that it be comprehensive. We wanted all serious allegations against the nominees to be investigated. And of course, we would expect in a comprehensive investigation that all appropriate witnesses be questioned. We asked that the FBI perform all logical steps related to these allegations, including, of course, interviewing other individuals who might have relevant information and gathering evidence related to the truthfulness of statements made in relation to these allegations. We got no response. Just yesterday, I joined a letter with many of my committee colleagues asking Chairman Grassley to prevent public mischaracterization or selected leaks of the results of the FBI's previous work. We urged him to, quote, call for a full Senate briefing by the FBI so that all senators hear the same information and have the same opportunity to question the FBI before any floor vote on the Kavanaugh nomination, end quote. These are requests having to do with the most recent FBI investigation. And we asked for a meeting between the chairman and the minority members to establish bipartisan ground rules for public discussion of the information provided by the FBI and this most recent, totally truncated and inadequate investigation. Those last were my words. Well, both requests were rejected. I had hoped the FBI would exhaust all possible avenues of investigation relevant to whether Judge Kavanaugh had a pattern of drinking that resulted in aggression and belligerence toward women. I had hoped they would follow leads given to them by Dr. Ford and Ms. Ramirez. I had hoped they would be permitted by the White House to do the job we know they can do, the job former Director James Comey said they could do. Instead, as we now know, they were only allowed to do the bare minimum. As we know from news reports, there are dozens of people with relevant information, some of whom say they have corroborating evidence who need to be interviewed, but they were not. It is simply impossible, after seeing the results of the FBI supplemental work, and I hesitate to call it an investigation, that anybody could think it was in any way, shape, or form the comprehensive investigation the president promised. This so-called investigation is a sham. It is a fig leaf for the Republicans to hide behind. It is a talking point for their continued and predictable criticism of Democrats They say, see, you wanted an FBI investigation, you got one, and now it isn't good enough for you. Who are they kidding? This is a sham investigation. Well, this so-called investigation wasn't good enough for me, and it shouldn't be good enough to satisfy the American people. Judge Kavanaugh has a burden. He has a burden, not a burden of proof like in a court, but the burden to show us he has not just the credentials for the job, but the temperament and the character necessary for this lifetime appointment. I have said many times that Democrats didn't need to manufacture reasons to oppose Judge Kavanaugh's elevation to the Supreme Court. Based on his record, his opinions, his dissents, his academic writings, and his speeches, I had concluded before these new reports came forward that he would not be fair and objective on the Supreme Court. His views on reproductive rights, native rights, and legal protections for workers, consumers, and the environment are all of deep concern to me. Not to mention his expansive views on executive power, including protecting a sitting president from criminal or civil proceedings. But now that we have heard Dr. Ford's account and seen Judge Kavanaugh's angry and combative reaction, it is evident that he should not serve on and should not be confirmed to the Supreme Court for a lifetime, decades of making decisions that impact our lives, that will impact our lives on all these areas that he has a very troubling record on. We can do better, and the American people deserve better. I yield the floor. Mr. President,
Senator for Hawaii.
I note the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.